Welcome to the Legal Soundbite for Q3 2023. In this edition, we'll be looking at some recent developments and related risk issues. First, residential conveyancing and the impact of the Building Safety Act 2022. The Act creates a new safety regime for high-rise buildings to prevent a repeat of the tragic fire at Grenfell Tower in June 2017 and to protect tenants from the considerable costs of remediation of defective cladding in existing buildings. For conveyancers, this means further work, particularly when acting for buyers of leaseholds in high-rise buildings. Amongst other things, this includes checking that the Act applies to the building, the lease was granted before 14 February 2022, the cut-off point for protection from cladding remediation costs. There's a landlord certificate confirming remediation cost protection or confirmation of protection of costs incurred pending remediation, such as waking watches, and that any requirements under the lender's handbook can be met, both the general requirements in Part 1 and any lender-specific requirements in Part 2. Firms need to be careful about limiting their retainer, for example, to avoid advising on building safety issues which really fall to other experts, and alive to potential delays in the certification process and the impact on any mortgage offer. One further potential trap is extending a lease, granted before 14th February 2022, which has the benefit of the Act. This will be a surrender and re-grant. The lease will then be after the cut-off date and fall outside the cost protection regime. Errors could lead to a range of claims. Loss of opportunity if delays mean the transaction goes off, diminution in value on purchasing a property liable to remediation costs, meeting remediation costs or the additional costs incurred before remediation if these were not dealt with in the transaction. The Act continues to be amended and it's a matter of watch this space for changes. The Law Society website is a useful resource as the Society raises the profession's concerns with the government and feeds back on developments. Another source is the Conveyancing Association and their Conveyancer Guidance Note, providing a useful checklist of issues. Next, wills, trusts and probate. As we mentioned in the first soundbite of the year, this is an area where we are seeing an increased share of notifications. We suspect that this is partly driven by property values boosting the size of estates, encouraging disappointed beneficiaries to challenge the validity of wills. One line of attack is testamentary capacity, or its lack, as in the recent case of Bolton Rees. The testatrix had been diagnosed with dementia in March 2013 before making her will in the following May. The testatrix solicitor did not seek medical advice following the diagnosis, as he was satisfied as to testamentary capacity. There was also psychiatric evidence in court that her condition would not have prevented her understanding what she was doing when she executed the will. Given this, and as the will appeared rational, it was upheld by the court. That said, the judge did express some doubts as to the testatrix capacity, given the dementia diagnosis. And dementia is generally on the rise. According to Alzheimer's Research UK, around 940,000 people are estimated to be living with the condition in the UK, predicted to reach 1.1 million by 2030. With the rising value of estates, this could mean increasing challenges to wills and questions for those who drafted them. So if you have doubts around a testator's or testatrix's mental capacity, consider getting a medical assessment, following the so-called Golden Rule in Kenwood and Adams from 1975.